I want to give you a brief overview of the divorce process in Arizona. A lot of my clients have questions about that, and so I want to just give you a quick rundown. In Arizona, a divorce is started by one of the parents filing a petition for dissolution. And there is not a whole lot of magic to the petition. There are a few basic requirements in the petition, and there are plenty of forms available on the internet that you can look at that will assist you in figuring out the type of things you have to put in a petition. In order to file a petition for dissolution in Arizona, you have to be a resident, you have to live here for at least 90 days. In order for the court to have jurisdiction over your children and to make decisions about your children, this law gets a little bit more complicated, but a general statement is that Arizona has to be the home state of the children. And by home state, that means it has to be the state that the children have lived in for 6 months, the last state the children have lived in for 6 months. One of the important documents that go with the petition is a preliminary injunction. This is a standard form. It is required to go out in all cases, and it orders that both parties shall not do anything unusual with their finances. They should not try to transfer or conceal property. They shouldn't liquidate accounts. They shouldn't take money and go to Las Vegas and spend it all. They shouldn't try to hide money. It basically says that anything you do beyond the normal course of business is forbidden and should not happen. Now, what is the normal course of business? If you're planning on selling a car anyway, you can do that, but you need to keep good track of it. You certainly could open your own checking account if you wanted to. If you were going to split up a joint account and put half in your account and half in the other spouse's account, that may be acceptable. But anything you do that is even slightly unusual, be sure you keep very good track of, because you may be held accountable for that. So you start the divorce by filing a petition, and you file that with the court, and the other party has to be served with those papers. A process server is usually the way that you get that process started. A process server goes to the home of the other person or goes to the workplace, and they hand them the papers, and then they file an affidavit with the court. It is also possible, if you are being more cooperative with your spouse, to have them sign something called an acceptance of service. An acceptance of service does not mean they agree with the petition, but it does mean that they waive the obligation for you to have a stranger serve them with the papers, and it acknowledges that they have 20 days to answer. After the divorce petition is filed, the other side has 20 days to reply. Now, even though that's what all the papers say, at the end of that 20 days, the party has to file something called an application for default, which is another final 10-day warning. So in most cases, realistically, you have 30 days to file an answer. Once the answer is filed, the earliest you can finalize a divorce in Arizona, even if you and your spouse agree on everything, is 60 days. That's a cooling off period that we have in Arizona to make sure that you are of clear head and mind about your divorce, and so that it's just not too easy to get a divorce. Most cases are contested. That means most cases have things that the parties don't immediately agree on. And in those cases, it will take somewhere between 6 months and 18 months for the whole divorce process to go through. One of the first things that you have to decide is whether you need temporary orders. If you cannot get along and share time with your children and come to financial agreements for the 6 to 18 months of the divorce process, you are able to get into court rather quickly, and by quickly I mean maybe a month to 2 months, and have a brief hearing. And at those brief hearings, the court can determine parenting time or custody arrangements for the children. In other words, how much time they will be with mom and how much time they will be with dad. The court can determine the temporary child support or spousal maintenance if that's an issue. And the court can also make temporary orders about payments of bills, who lives in the house, and things like that. Oftentimes, parents don't need temporary orders. They can reach those temporary informal agreements by themselves. I always recommend that they get those in writing. It can be an email back and forth or a couple of texts, but it's always good to have something in writing if you've reached a temporary agreement. If you have minor children involved in the case, then both parents have to attend mandatory parent education. Mandatory parent education is a half-day class. It usually occurs on a Saturday, and you have to attend that class within 40 days of the petition being filed. It's not a class so much about how to parent. It's really a class about how to get along with each other when the parents are not living together. It talks about communication. It talks about trying not to fight in front of the kids. It talks about not using the kids as go-betweens. Most of my clients find that this parent education class is very helpful, and the court requires you to go to that parent education class before you go to mediation and before you have any kind of a final hearing in the matter. Whether or not you need temporary orders, the next stage of the divorce process is the discovery and disclosure stage. And simply put, this is several months of exchanging information. If it's a complicated case where the parents may own a business, and they may have complicated retirement plans or debts or several homes, then they have to disclose information back and forth to each other. Typical information that you would know with common sense. Checking account statements, profit and loss statements, articles of incorporation if there's a business, check stubs, tax returns, witness statements, things like that, so that both sides, well before they go to trial, have a really good idea of what the position each party is taking is. After the period of disclosure, the next thing that happens is a trial date is set. That trial date is set usually by one of the parties setting the matter for trial. Once the trial date is set, things are getting very serious. The court issues a minute entry or an order about deadlines. There is usually a pretrial statement that needs to be filed where you list all of your witnesses and exhibits, you list your position, you fill out a detailed financial affidavit, and you fill out a detailed inventory of property that lists all of the property and debt and how you want those things taken care of. If you are still arguing about your children before your final trial, you will be required to go to mediation. Mediation is a service provided by Pima County Conciliation Court, and the two of you meet with a very good trained counselor who will try to get you to reach an agreement about the children. The mediation is only about the children. It is not about financial issues. And if you reach an agreement, they will draw up a very detailed parenting plan that describes holidays, it describes communication, it describes transportation, vacations. It's a very good service, and many, many people reach an agreement when they go to mediation. Prior to the final trial in Pima County, we require that the parties have a settlement conference, and that's where they meet with a volunteer lawyer who has certain powers of a judge, and that lawyer really tries to get the parties to settle. That settlement conference is confidential, so if you don't reach a settlement, it cannot be held against you that you made certain offers to the other party. If after all these settlement opportunities you are not able to reach a final agreement, then you have your trial. And the trial is where you put on your witnesses, you put on your exhibits. One party goes first, the other party goes second. You've probably seen movies about this, some of them not very realistic, but that's when you get on the stand, you testify, there's cross-examination, and then after the court has heard all of the evidence, then the judge usually takes the matter under advisement where he has a time period to think about it. That time period is 60 days, although most judges rule before that, and then you get a final written ruling from the judge, and the judge makes the decisions that you cannot agree on, and that is turned into a final decree, and then you live, hopefully, happily ever after.